Okay, it is Monday, October the 21st, 2019, and welcome to week 4 of constitutional law. And as I said before, the quarter is going extremely fast, and that this quarter will be over before you know it. And that the quarter we'll have 2 more quarters. Now, what I said before, I'll say it again. All assignments from weeks 1 to 3 that are not turned in by the end of this week, which is Saturday, as far as I'm concerned, not Sunday, but the end of this week is Saturday. Well, I'll just go ahead and do it right. I'll give you till Sunday, the complete week. So by Sunday at 11:59 p.m. Central Standard Time, if you have not turned in weeks 1, 2, and 3, and I have not given you extenuating circumstances, and my recollection is no one in this class has provided me extenuating circumstances why they couldn't have done weeks 1, 2, and 3, I will not accept them as late assignments. Because you actually will be beyond the 7 days, and I'm not going to give you grace periods from that point. So that means that weeks 4, 5, and 6 would be the ones that you'd submit. Okay? So understand what I just said. Clearly, you understand if it's week 1 assignment, of course, you're way over 7 days. If it's week 2, you're over 7 days. If it's week 3, your week 3 assignments were due on this past Sunday, and that by this Sunday coming up, you will be 7 days. So no deals after that. All right. So let's go ahead and let's get started. Let me go into my module. Okay, and so you see here my instructor information. You see the additional course information and details here. And so let's go down to the rubric for week 4. So week 4, your assignment is the Supreme Court case of Gant versus Arizona. And you're going to apply the rationales from that case in an analysis to receive 45 points. And then you're going to deal with the question, is this legal? And if it's legal, why is it legal? If it's not legal, why is it not legal? And then, of course, you're going to satisfy the page requirements, which you will see in the module itself, along with the APA, which you already know by now what I'm expecting for that in order to get your 80 points. Now, that's your written assignment. The next thing will be your course project. Your course project, this is the third part of your Fourth Amendment project. So what you have to do in this is choose and describe the circumstances surrounding a current case or event relevant to the Fourth Amendment, and include options and a short explanation of how the case fits in to your overall paper based on the area that you selected during week 2. Includes a thesis statement for this project, and then satisfies the APA requirements, spelling, paragraphs, and all of that, or else you'll lose 10 points. All right? So those are the requirements. I'm going to go specifically into the page and all that in a minute. And then reminding you that we have just 2 more lectures after today, weeks 5 and week 6. All right, 8:30 to 9:30. And then you see here the recordings for each of the 3 lectures that we've had so far here. So now let's go over and let's take a look at the 4th week. Let's look at the announcement that we have for week 4. That's the welcome announcement. Let's close that down, which you know that already. Here we go, right here. So for this 4th week, Module 4, Searches and Seizures, which, as you already know, is a part of the 4th Amendment, or you should know by now. And to prepare for this assignment, I have provided for you Chapters 7, 8, and 9 of the textbook in the PowerPoints and additional information to help you and assist you. And then we're going to talk about reasonable suspicion and probable cause. And we're going to talk about the difference between the two, and we're going to talk a little bit about warrants as well. And then be aware that your discussion post, your initial post, is due tomorrow night, the 22nd of October, by 11:59 p.m. Central Standard Time, and the topic is seizure or not. And then the other one is punishing the police. So last week, week 3, you only had 1 discussion post. Weeks 2 and week 1, you had 2 discussion posts, 2 discussion subtopics, and you have 2 this week as well. Finally, you're going to complete 2 assignments I just talked about, Gantt versus Arizona, and then the 4th Amendment project current topics, which pay attention to the rubrics and what's in the module. Then you already know what adversity is a springboard to success. And again, before we get to the assignments in specific, in detail, let's take a quick look at the course calendar. And you can see it right here. This is where we are right now. Your reading assignment, and there it is as I shared it with you a few minutes ago. And then your initial post on both topics tomorrow night, your reply post on both topics Saturday night the 26th, and then the 27th, then you will have your written assignment and your 4th Amendment, and then your key phrase. And remember, once again, and it's not on the calendar, but it's the last day that I will accept the assignments. So you know what I'm going to do? I'm going to do this. I'm going to do this just so to help you. All day. Okay. Last day to submit assignments from weeks 1 through 3. Now, the discussion posts cannot apply to this okay, and you know why. So I'm going to put save. So now that's on the calendar. So that's a reminder, is that the last day to submit assignments from weeks 1 to 3, with the exception of discussion posts, is the 27th as well. So now you have it in your calendar, and you heard me talk about it in the lecture. You have no excuse for missing it. And then next week, we will have week 5's lecture, and then that'll be the last one for this month. And then we'll have one on the 4th, which is your very last one. And then you go to November 4th, and you will see that the course ends that Sunday, the 10th. All right? So that's the course calendar. And if you have any concerns about it, you know, because you're not confused. And I'm giving you forewarning so that we are on one accord and on point when it comes to that. So now let's go to our topic of search and seizure. And again, let's take a quick look at the assignment and see what the requirements for the number of pages. So this is the course project. and it told you what to do. So now you know it's a 1 to 2 page paper. Make sure you run your papers through Grammarly, because you will go hit with Grammarly percentages. I've been sharing that, and then you guys are in the bachelor program, so you should be very well familiar with using Grammarly as well. And it tells you what you should do. And I'm going to be looking for all of these bullet points to be included. And again, compare that with your rubric. And again, just a reminder, it is due as soon as it pops up this Sunday, which is the 27th. All right. Okay, so now, Gant versus Ohio. This is the case, and it is a new Supreme Court case from 2009, which sounds funny to say that because that's 10 years ago. But what it does is it limits the search incident to arrest exception, which is an exception to obtaining a warrant. And so you can research this case and skim the actual opinion, apply the rationale found in this case to the following fact pattern with a 1 to 2 page analysis. One of the things that you can do, as I would do, I would prepare a brief for myself to brief the case so that I would have, and that's what we did, that's what we usually do, is we read the case and we brief it so that we can get a clear understanding. And so you're going to use these facts that are included, and you're going to answer the question, is it legal under the holding in Arizona versus Gant or Gant versus Arizona. All right, and then you're going to submit it, Microsoft Word, no PDF. All right, and that's what you're going to submit when we get to this. And here's the due date. You'll see the same due date, which is the 27th. Here it is. Okay. So those are your written assignments, your discussion post, seizure or not, and you're going to deal with these issues as well. Okay. Some of you have already started responding to that, and then the question of punishing the police. And so the question that is generally asked here, and I hear it all the time, and I remember when I was a police officer, should the police who conduct unreasonable searches in violation of the Fourth Amendment, should they be allowed to do that? And do I think that officers should be criminally prosecuted for violation of these freedoms? And I'm not going to express my position right now, but I have some strong positions about that in terms of whether or not punishment should take place. And when I say punishment, generally I'm talking about criminally prosecuted, not civil, because civil cases can come about quite easily. And then your live key phrase that I'll give at the end. And those are the assignments for week 4, along with details about what to expect in terms of getting your grades there. And so I already told you chapters 7, 8, and 9 that you're reading, and what we're gonna cover in this discussion today: probable cause, reasonable suspicion, and warrants. And then so these are this is your current topic for a course project. We already talked about that. We talked about Gant versus Arizona. We talked about the discussion posts for the two, and then your live lecture. So let's start right in, and let's get to the topic at hand here. So as you already know, that a good portion of criminal law is involved with the Fourth Amendment and the question of unreasonable search and seizures under the Fourth Amendment, and that there are various rules which require that in order to conduct a search, that there should be probable cause and in some instances, reasonable suspicion. And so we're going to talk about the difference between the two and how they apply. All right. So you should be familiar with reasonable suspicion pretty much, because I think from memory, my recollection is that your assignment last week was, in terms of briefing a case, I think it was Terry versus Ohio. It might have been Matt versus Ohio, but anyway, I think it was Terry versus Ohio. But at any rate, the point, let me see, I want to clarify that for sure. Let's take a look at week 3. It might have been, yeah, it was, let's see what it says, just so to refresh my memory. Okay. Oh, it was week 2 I'm looking for, not week 3, I'm sorry. When you started, let's see. Briefing a case. It was Terry versus Ohio. Yeah, that's what I thought. I thought it was Terry versus Ohio. That was when you briefed the case, so you guys should be very familiar with that in terms of dealing with the discussion that we're going to talk about here. So it was Terry versus Ohio. I thought I was right, but you know, I'm old man, sometimes you got to make sure. So anyway, so it is very important to understand the difference between what is reasonable suspicion and what is probable cause. Oftentimes I've read students will answer in a discussion both or include in their papers situations, and they'll try to use probable cause and reasonable suspicion interchangeably, or they'll inappropriately use reasonable suspicion when the standard is probable cause. And so you're going to learn that they are not the same. As it says, they are not different. They're not the same, and they are very different standards. And so it is, and it says here that a search is not the same as a seizure, and a seizure is not the same as an arrest. So we're gonna cover those issues right now. So let's start by talking about what reasonable suspicion is. And the famous case, Terry versus Ohio, which you guys are well familiar with because you briefed that case. And it's we call this the famous stop and frisk case. And it means what it says. And so it's a lesser standard. So in order to have this, and it has to be brief. It's not a long stop, but it has to fit within elements that if a reasonable person in the same circumstances could reasonably believe a person has been or is about to be engaged in criminal activity. So it says a reasonable person, and that should apply to police officers all over. And the circumstances should put in the mind what a reasonable person would look at and say, yeah, that person either is about to commit a crime or has already committed a crime and trying to cover it up. And so in that situation, and it's going to look at the totality, as it says, of the circumstances. It's going to look at everything. You don't pick just one thing. You have to look at it. And it's based upon certain specific articulable facts, such as, for example, if a person is peeping in a window, police driving down the street, and a person is peeping in through the glass of the window, that alone is not adequate for a stop or frisk. Now, it could, depending on the time of day. Let's say if it's during the time when business stores open and somebody's doing that to look inside and see if there's anybody in there. But let's say it's 1 or 2 in the morning or late at night, or it's a time when the business is clearly closed, and a person is doing that. In that situation, then the Terry stop allows that person to be stopped, ask some questions, and the officer is allowed to pat that person down. And the purpose for the pat down is not to get evidence primarily. The purpose of the pat down is to determine if that individual has weapons. And if there is an indication that that person has weapons, or that person might have a screwdriver or something that is a burglar tool, or something that uses burglar tools, or something along those lines, then that person, they can seize that information. But the key thing is that you have to be very careful about that kind of thing. And it's the immediate of the person that it must involve. And so Terry versus Ohio. So it's a reasonable suspicion that's needed for a stop, there's a brief, or a frisk. And the frisk, I said, is the pat down. You can't just stop the person and start going into their pockets. You have to have a basis for it. So that's why it's called stop and frisk. A frisk is defined as patting a person down or something along those lines. Now that you got that in your mind, now let's talk about what probable cause is. Now this is the higher standard. It's needed for a warrant or arrest or a search. And it's the higher of the two standards. And there must be reasonable belief that a person committed, ED, also used as a standard for grand juries, committed a crime. Now look at the standard from the other. If a reasonable person in the same circumstance would reasonably believe a person has been or is about to engage in a crime, but reasonable belief that a person has committed a crime, then in that case, that would be. So let's say, for example, a person is in front of the same store I told you about a few minutes ago, and instead of looking in, they have a brick in their hand, and they're about to throw that brick. And then, in fact, they take that brick and throw that brick down. So then, in that case, they take off running. And so, did the person really commit a crime at that point? Probably not. What if they took the brick and threw it against the window and then stood there or took off and ran? Then probable cause would be needed for an arrest or warrant, except if it's done in plain view. Remember, you got these exceptions that are to warrants, and you know we have those we're going to talk about in a few minutes. And I don't know, yeah, plain view. We're going to talk about that, and these are exceptions. But generally, in order for a person to conduct a search or arrest, there is a need for a warrant unless it falls into one of these exceptions that I'm going to share with you in a few minutes. So it's a high standard. And so when you look at the Fourth Amendment, where it says, and I give you what it says, pretty much in how it works, is that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and that no warrant can be issued but upon probable cause. The way warrants are issued is that a law enforcement officer goes before a magistrate or judge with an affidavit affirming what they observe in order to determine that probable cause is present, and the judge, listening to all the, or magistrate to all of those circumstances, will determine whether or not to issue a warrant. But it's got to be probable cause that the person is doing so. There are people who, we have cases where people have a police officer in the area, and the police officer is in a place where they're supposed to be, and they smell marijuana, and the person may hide the cigarettes, but they're in that vicinity. Then in that case, they may be able to arrest that person, or if it's probable cause, because if a reasonable person believes that that person committed a crime, that i.e. smoking marijuana when it's illegal or in a place where it's illegal, then in that case they could. But it says shall not be violated, and no warrants are going to be able to be issued unless probable cause, and as said, supported by oath or affirmation. That's what I'm talking about in terms of the affidavit that's submitted, describing the place to be searched. Now that's for search of a place and or the persons or things, and it can also include reasons why that person you issue an arrest warrant. Let's say, for example, if a person is seen on video committing a crime, and that video is viewed by the police can take that video as evidence before a judge and issue a warrant. Now, in that case, they got to know the name of that person and that kind of thing. Now, if it's searching premises, they have to have specifics of that location. If they're going to arrest a person, they have to have as close to specific as they can of the name of that person in order to arrest that individual. So that's how probable cause. Probable cause, to put it in a nutshell to you guys so that you can clearly have a picture of it, ask yourself, is that person committing a crime, or have they committed a crime? And excuse me. And if they have, and then you can't always arrest them except with one of these exceptions here. If you do arrest them and then you don't have a warrant, you're going to have the burden of establishing that one of these requirements that I'm about to cover are satisfied. Okay, so now let's talk about how warrants apply in terms of the Fourth Amendment, which I've already told you. You have to have a warrant to make an arrest, enter a home, or conduct a search, unless it fits under one of these 6 exceptions. First one let's talk about is very straightforward: consent. If a person says yes, you can search, and they allow you to, they consent to a search, then you don't need a warrant. But keep in mind that the consent must be voluntary. So let's say, for example, you stop me and you have a gun on me, then you ask me if you can search, and then I say yes. The question that would be open for any judge is, would that be voluntary? Probably not, because there may be some coercion involved because of the presence of that weapon. If a person is surrounded and then ask to search, so basically it has to really, looking at all the facts and circumstances, be pretty clear that that individual participated willingly in allowing that consent. It comes in quite frequently in vehicle searches, but it comes in searches as well, and those kind of things. A search incident to an arrest. Now, we've kind of talked about that with the Gantt case. So if a person is arrested, they're arrested upon probable cause, then the officer can search the area in the arrestee's immediate surroundings for safety or to prevent destruction of evidence. Immediate area, okay? Now, once you're arrested, one of the things that you generally will do is probably handcuff the individual, all right? So if you're going to get a search incident to an arrest exception in here, it's going to have to be in a situation where you have that individual under arrest, and then you need to search the area to make sure that there are no weapons, no bombs, or nothing like that to prevent destruction of evidence. So it's a very limited thing. And then when you get into Gantt, Arizona versus Gantt, and here's what I'm going to go over with you, and it gives you a tip in terms of how to do that assignment that you have. This exception was limited even more by the Gantt case, saying that in the search of a car after a person's arrested, officers can only search the car if they have a reasonable belief that the arrestee's car is within their immediate control, or if evidence of the crime which the person is being arrested could be found in the car. For example, if the defendant was arrested while driving for driving while his license is suspended, the officers couldn't use the second part of the test to search the car because there would be no evidence of him driving while his license is suspended found in the car. Where would you find that evidence? In checking your computer. And so you can't just go through a car and search just because of that. That's what kind of like what Gantt is saying, and it kind of makes sense. So it makes it so that your search incident to an arrest clearly has to be a search in the immediate surroundings and for the officer's safety or to prevent the destruction of evidence. So if the person is being stopped for suspended license, then you can't, like, oh, could you open your trunk? No. You shouldn't be looking in the back seat. You shouldn't be looking in glove compartments and those kind of things in that kind of a scenario. All right? So, but there's some other circumstances that might make it more so. We'll talk about that in a minute. So the third one, plain view, it describes what it means what it says. If the officer is legally searching an area with a warrant or with the consent of the owner, and the officer comes across some contraband or evidence of a crime, in his plain view, he may seize the evidence without a warrant. So some argue that smelling it puts you in plain view, but definitely seeing it puts it in plain view. And that's the most common way that plain view exception exists. Let's say you stop a car and a person is stopped for a suspended license. And when you go to the car and you ask the person for their license and registration, you look over and you see a gun on the seat or on the floor in the front. Well, that's going to get you in a plain view exception situation there, okay? And that makes sense, all right? The next one is automobile exception. Now, this is one that we have a lot of fun as defense attorneys dealing with in terms of representing people. Because the car is, as it says, mobile, it moves, and there's an increased risk that evidence can be destroyed. Officers don't need a warrant to search a car where they have probable cause. You hear me? First, they got to have probable cause that there is evidence of a crime within the car, okay? They have to have probable cause that there is evidence that may be destroyed. So let's say, for example, that if you stop a person and a car, and that you see white powder on the seats, it is probably going to be the automobile exception to be able to possibly check the motor vehicle's trunk, possibly glove compartment, and places like that for further amounts of cocaine or drugs, because those drugs then are in plain view. But because it is a car, there is an increased risk that evidence may be destroyed, and officers will need a warrant where they have probable cause. It also applies to other mobile vehicles like boats and things of that nature. But this rule is limited to areas where the contraband could be found. For example, if there's probable cause that a bicycle was stolen and is in the trunk of the car that is being searched, the officers can't open up the glove compartment to look for the bike, because you're not going to be finding a bike in the glove compartment. So you open up that glove compartment and you find a gun, but you're looking for a bike. It's going to get thrown out because it doesn't fit in the automobile exception. So it has to be reasonably based upon the place that it might be. So the one I gave you on cocaine, is that possible? Yes, because that's a different scenario, because cocaine can fit in the glove, it can fit up under seats, and it can fit in the trunk as well. So then we get to two more. Excuse me. Exigent circumstances. Exigent means emergency circumstances, kind of. So where there is a threat of harm, emergency, or possible destruction of evidence, officers can enter a premise without a warrant. So let's say, for example, you're chasing John, and John has some drugs or something, and John took off running, and John runs into a house. Then, because this is an exigent circumstance, there is a threat that the evidence could be destroyed, such as what has commonly happened and occurred, and we've had it happen. Common sense, flushing it down the toilet, putting it in the drain, those kinds of things. Or there is a threat of harm. The person has a weapon, and they're taking off running with that weapon. Then, in that case, then that is another exigent circumstance where you don't have to say, okay, I got to stop and get a warrant. No. You can continue to chase that person as well. In the United States, if a person crosses the state line and the crime is committed in your state, and the person, you can pursue the person across the state lines because of the exigent circumstances rule as well, and also because of the automobile exception rule as well. Risk, stop and frisk, the final one. Stop and frisk. We talked about that already, so we don't really have to get into detail, but it says what it says. An officer may stop and frisk a person, that is, pat them down, if they have reasonable suspicion based upon articulable facts that the person has committed or is in the process of committing a crime. So this video here, I'm not going to go over. You can take time to look at how I and several other criminal defense lawyers talk about the exceptions, talk more about these same exceptions to the warrant requirement. Take a look at them. You'll be able to learn some things. I think that they're available, and if you have trouble clicking on them, let me just check to see if you can get to them. Because sometimes the links they have are not that good. Let's see. I guess not. I'll have to talk to personal support about these. Let me see if it allows you to open link by right click. Let's see. Let's see. Okay. Okay, it might allow you to do it through that. And so anyway, I'm not going to get into it. If it's something you got to sign up for and pay, don't worry about it. Video management. Let's see if that works. Open link in new window. Yeah, I'm not sure how they arrive at some of these things here. So I'm going to just tell you, let's see. Okay, so I don't know how they work, but I'll talk to PSC about it. But the key thing here is be aware that of how these things work based on this. Okay? So I want to leave you with a key phrase. And that key phrase is stop and frisk. That's it. Give me that. Have it spelled correctly, and you will get your points. Remember, due to 27th, which is Sunday, 11:59 p.m. Central Standard Time. And with that, I'm going to say good night to you, and I'll see you next week. Good night.